Good morning, and welcome to our Filice webinar on wage and hour law topics. We have two presenters joining us today from Astra Law Group, a boutique law firm located in San Francisco, California. David Mead has been a trial lawyer for more than 25 years. He represents private companies, public entities, and individuals in a wide range of business and employment law disputes. Wendy Hilger has been practicing law for almost 20 years. Her practice includes business disputes, employment matters, real estate claims, and insurance litigation. David and Wendy focus on advising businesses concerning all aspects of the employer-employee relationship. And then for those of you who aren't familiar with who we are at Filice Insurance, we are an employee benefits consulting firm headquartered in San Jose, California, where we practice in various areas of expertise, including brokerage services, HR compliance and support, and benefit plan compliance. We are the 26th ranked large group broker in the nation, and we were recently named the second best place to work in Silicon Valley. We are pleased to again be partnering with David and Wendy from Astra. So without further ado, I will hand things over to David.
Good morning, everybody. We're glad to have your attendance today, and we hope we can provide you with some information that you can use going forward in your various jobs and capacities. To give you a general outline of what we plan to do this morning, I will be speaking for about 30 minutes on sort of the substance of law related to the question of who's considered an employee and who's considered an independent contractor, the exemption from the overtime law requirements, who's exempt, who's non-exempt, and then the meal periods and rest periods that are required under California law, which have caused a lot of consternation for many employers in recent years. When I'm done, about 30 minutes, my colleague Wendy will spend 15 minutes talking about best practices to do when you receive a notice of an audit or expect to be sued. Throughout the presentation, you can type us questions, and we will try our best to answer those questions during the course of our presentations as the questions arise. And we'll also leave some time at the end, 10 minutes or so, for follow-up questions after the presentation is completed. And so with that, let me get started on the first meaty question of the day. And that is, independent contractor or employee? By way of background, most of you probably know that hiring an independent contractor has certain financial benefits for most companies because the independent contractors are not subject to the wage and hour laws. You don't have to pay payroll taxes on their behalf. You don't have to pay workers' comp on their behalf. They're not subject to the anti-discrimination laws. There are a whole host of reasons why hiring an independent contractor is more favorable for a company, generally speaking. And so, of course, in our economy these days, companies try their best to categorize independent contractors in order to reap those benefits. But what they mostly don't understand is that the determination of who is an independent contractor and who is an employee is quite complicated. And it's not easy to do, actually. And in fact, nowadays, most people who are classified as independent contractors truly are employees. And when those independent contractors get fired or terminated, they run to the Department of Labor and file a claim against the employer, and that can lead to a lot of negative repercussions. So the problem for employers is that the term independent contractor doesn't have a set definition, and in fact, what it means for purposes of the Department of Labor and the Wage and Hour Division can be completely different from what it means in another sector of the government. And it's not uncommon for somebody to be characterized as an employee for one purpose and an independent contractor for another. So today we're focusing on that definition, or how courts have treated it with respect to the Department of Labor and the wage and hour requirements. Workers who provide personal services are presumed to be employees. That's the starting point. It's then the burden on the employer to establish that the worker is in fact an independent contractor. So you've got an uphill battle from the get-go. And the Department of Labor and the courts in California have developed a very fact-specific contextual test to determine whether someone's an employee or an independent contractor. It's called the economic realities test. And it's described in great length in a case in California called, by the California Supreme Court that we refer to as the Borrello decision. We'll talk a little bit about the factors that the court laid out in that decision. But a couple of things at the get-go you should realize is that the fact that you've got a written contract with an independent contractor in which both parties agree that the person is an independent contractor does not definitively prove that they are an independent contractor. The Labor Department and the courts will look beyond the words in the agreement to see what it is that the person's actually doing in order to decide whether they are an employee or not. And similarly, of course, you're not processing your independent contractors through payroll, and you're issuing them a 1099 each year rather than a W-2. That has the same problem. It's not a definitive indication that the person is an independent contractor, and the courts, the Department of Labor, passed that to make the decision. So where do you start? Well, the single most important factor the courts look at has to do with the right to control the work. And so that most of the questions in factual investigation involved in determining whether somebody is an independent contractor or an employee focus on this issue. Does the person who's providing the service control the work themselves? Do they determine their own hours? Do they decide the manner and means by which they're going to perform the work? Or does the employer or the principal do that? It's frequently the case that a principal will hire somebody as an independent contractor and say to them, well, look, here's what I need you to do. Here's the project. I don't care, how you do it, how you go about it. You can decide that for yourself. You can work from home. Here's the result I want to see. Here's my deadline. Go take care of the work. You're on your own, and you're an independent contractor. Most of the time, or many times, that would be a sufficient indication that the person's not an employee. But the Department of Labor and the courts go beyond that. Even if the employer or principal is not exercising a great deal of control over the work, nevertheless, there will be an employer relationship if the principal retains pervasive control over the operation, the worker's duties are an integral part of it, and the nature of the work makes detailed control unnecessary. And let me give you a couple of examples of this from court decisions and the recent Uber decision. So in the Borrello case, the employer hired people to harvest cucumbers. And the cucumber harvesters entered into an agreement, a written agreement with the employer called a share farmer agreement, under which part of their compensation was dependent on their profitability. When some of these workers got injured on the job, they made a claim for workers' comp, and of course they had no workers' comp because the employer hadn't insured them. The California Supreme Court held that these cucumber harvesters were in fact employees entitled to workers' compensation benefits, despite the agreement that they had, despite the fact that they controlled when they worked, how they harvested the cucumbers. And it had to do with the fact that the employer was in the business of growing, producing, and selling cucumbers, and the workers were one piece of that process. And as a result, generally speaking, they got characterized as employees. In a second opinion called the Yellow Cab case, a cab driver had a lease agreement with a yellow cab to lease a cab and drive his cab, and he had set his own hours, and he paid a lease fee to the yellow cab company, and he got injured on the job, sought workers' comp benefits, and the same thing happened. The court in this case ultimately determined that the cab driver was in fact an employee, even though he decided when he worked, what hours he worked, and so on and so forth. And in the recent Uber decision, I don't know if you've heard about this, the Department of Labor applied that same analysis to decide that drivers for Uber were in fact employees and not independent contractors. Uber's argument was, hey, all we're doing is we're providing a smartphone platform that connects drivers and passengers. We're just sort of a neutral middleman here. But the labor commissioner who decided the case said, no, just like Borello and Yellow Cab, the nature of your business is to provide transportation services, and the drivers accomplish that for you. They're an integral part of the business. Without the drivers, you would not be able to provide the passengers with the service that they're seeking. And in fact, Uber does exercise a certain degree of control over the entire process. For example, they provide the smartphones to the drivers. They have certain regulations about the type of car that a driver can drive. They have obviously the rating system that allows drivers and employee and passengers to rate each other. All these things make the service better, but they're all aspects of the conduct of the business that Uber controls. And so as a result, Uber was on the wrong side of the decision by the Department of Labor. Now, Uber being Uber, they have decided to appeal that decision, and the courts will have a chance to weigh in on it. Who knows, maybe a court will come to a different conclusion. But if I had to guess about that, I'd say probably not. Interestingly, Lyft was recently sued by the same attorney who's going after Uber for the same thing, and announced almost immediately that they were going to classify all the rest as employees. So there are a number of other factors that the Labor Department and the court will consider. I've got them listed here on the slides, and you'll be able to obtain a copy of this presentation after the program is over. I'm not going to go through each of these in great detail, but what I would just point out is that these factors are designed to determine whether somebody is performing a service or a business that's different from the work that the employer or the principal performs. So the easy example is somebody who's, let's say, a painter, contracting company that paints, and you hire the contractor to come in and repaint your office space. That person's providing a separate and independent service that's not related to the particular business that you operate, unless you happen to be a painting contractor, and that's your typical independent contractor situation. But now take the Uber example as a contrast. The person who is coming in to work for Uber, although they have their own cars, set their own hours, decide when they want to work, yada, 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 that person is providing a service that is at the core function of the business's services. And so many of the independent contractors that are out there nowadays fit within that type of category. Not all of them, but many do. And so our basic advice to employers is, look, if you're considering hiring somebody as an independent contractor, enter into a contract, put them on a 1099, but first and foremost, have somebody, a lawyer or a HR professional, review the factual specifics of the job, the nature of the business that you run, and analyze each of these factors to determine where you come out on the scale of independent versus employee. Because in some cases, one or more of these factors might weigh towards somebody being an independent contractor, but others might weigh more towards that person being an employee. And as an employer, you have to evaluate the risks of misclassifying somebody, obviously. And if you're aware that there are factors that tend to indicate somebody's an employee rather than an independent contractor, if you're risk averse, you're probably better off categorizing them as an employee. So those last several slides there identify the various factors that the courts and the Labor Department will consider. So what happens if you get it wrong? Well, it can be very expensive. In Uber's case, the employee was awarded her business expenses, which consisted of the cost of gas and mileage on her car. But what happens in most of these cases when you get it wrong is that a independent contractor will make a claim for unpaid overtime and missed meal breaks and rest breaks, which they'd be entitled to as employees. And if that's the case, you'll suddenly find yourself on the hook for overtime, unpaid overtime, meal periods, rest periods that haven't been paid. And we're going to get to that next. And in many cases, the employer may be on the hook for unpaid benefits. In the famous Microsoft case from about 20 years ago, a bunch of contractors who were doing computer support software work for Microsoft were deemed by the IRS to be employees and entitled to millions of dollars of retirement benefits that were paid to regular employees of Microsoft, but not the independent contractors. Of course, they'd also be responsible for waiting time penalties, which is a provision of the labor code that allows an employee to collect 30 days of unpaid pay as a penalty, as a waiting time penalty for not having received it at the time they did the work. I'm trying to look at the questions here as we go. There are also other penalties under the labor code that may kick in, and as well as interest and other things. Let me take a moment here to take a quick look at the questions that have been coming in here.
Sure. Dave, if you would look at Julie's question. I've marked it and answered yes.
Okay.
And
when
then
an employee is hired,
we
we have
other questions.
Yeah, we have to submit their info with EDD. I was told that I needed to submit independent contractors as well. Well, we're focusing on the wage and hour issues today, but it's true that the EDD, what is true is that the EDD considers whether somebody's an employer or an independent contractor under a different test. And so you may, in fact, need to do that to cover your bases. But let me look at Jody's questions here. I own several apartment units I hire as independent contractors to do maintenance work on occasion, not on a regular basis. I do not send 1099s. Are rules for issuing 1099s different for apartment owners? I don't think so. You probably should be issuing those folks 1099s. Let's see here. If I send 1099s, does it raise red flags that I may have an employee versus an independent contractor? To the contrary, that's an indication that you consider that person to be an independent contractor. You're not running them through your payroll. So let me go back to the live view here. I'm seeing the questions here are being displayed. Can everybody see the questions? I think they might be able to. All right. So what's next? The next step in the analysis here is who's exempt from being paid overtime. All of the folks that I'm talking about now are employees, but some employees are exempt from overtime. And the biggest types of employees who are exempt are what I call Ps, or white-collar employees, computer software employees, and outside salespersons. In the Department of Labor, they have a series of orders that lay out the wage and hour requirements for various industries and occupations. And the folks that I'm talking about now, who are exempt from overtime laws, are identified in these orders at various places and made exempt from them in the industries or occupations to which they pertain. But let's take a little bit of a look at who these folks are. And professionals is category number 1. Oh, by the way, let me mention that there are a whole set of rules that tell you how much overtime you have to pay and when that pertain to employees. We're not covering that today. We're just talking about who's exempt, just so you know. And another thing I'd like to point out is that frequently California law and federal law are different, have different requirements. And most of the time, California's requirements are stricter or more employee-friendly. And when they are, the employer's obligation in California is to apply the more stringent law, which is usually California law, to the treatment of their employees. So, for example, here for professionals, most professionals are the typical professionals you would ordinarily think of: lawyers, doctors, dentists, and so on. These are people who have a license from the state and are considered professionals because of their learning and certification. But professionals also include people who aren't necessarily licensed by the state, but are working in a learned or artistic profession. And this would, for example, include people who are doing something that's learned. Generally, are people who have postgraduate degrees and are doing something that requires a great deal of special skill and training. The artistic professions include music, writing, theater, the arts, those kinds of things. All of the people working in these areas can be exempt employees, but in every case, they should be doing so in a way where they're exercising independent judgment, where they have the discretion to make independent judgment calls. And then lastly, they have to have a minimum salary. In California, the minimum salary has to be 2 times minimum wage or more. That is actually less than $20,000 a year. But the federal law actually has a higher requirement. And just yesterday, the U.S. Department of Labor proposed to increase its baseline minimum salary requirements to about $50,000. The purpose of this proposed change in federal law is to provide overtime to many sort of lower-level managers, say the managers of small restaurants or food chains, with the opportunity to earn overtime. That law is not the law yet. It's just a proposal by the Department of Labor, and we'll have to see where that goes. But it could impact the number of people who are entitled to overtime. The next category are executives, these are, the obvious ones are your C-level employees, CEOs, CFOs, so on and so forth. These are people who are involved in the management of the entire business, or they run a department or a subdivision of a business. And these executives, an executive also has to be somebody who manages other employees, 2 or more other employees, and must have the authority to hire or fire other employees, or have the ability to make recommendations about hiring or firing that would, as the department says, that will be given particular weight. That's somewhat vague, but there are instances where somebody who's at a quite low level of management in a company would be exempt from the overtime requirements.
Before you leave this area, we have a question from the chat room asking about graphic designers and web designers, social media bloggers. Are those artistic professionals under your prior slide?
They might be. It really depends. They might also, yes, they might be. You'd have to look very carefully at exactly what it is that they do. And in particular, I would focus on whether they exercise discretion and independent judgment. Because many people they're supervised to a degree that would not make them considered professionals. So that would be the key. So let's see here. We talked about executives. So now let's go on to administrators. Administrators are the third category of white-collar worker. And hold on a second here. Wendy, are you there? Are you on the phone,
yes.
Wendy? Here we go.
Yes,
I couldn't see the slide for a second. That's all right. This category, administrators, is the one that trips up most employers. And there's a couple of things to note about it. These are folks who are performing administrative tasks, office work, not manual work. They're not involved in production. They're the typical example of somebody who would fit into the administrator exemption as an executive assistant to a high-level executive or administrator, or somebody, and they must be somebody who the boss, to use a short phrase here, has delegated some part of the boss's discretionary power. The administrator has to have the authority or power to make independent choices. They have to be free from direction or supervision and with respect to matters of significance. So to give you some examples of the types of people who qualify as administrators, we're talking about tax experts, insurance experts, foreign exchange consultants, statisticians, credit managers, purchasing agents, buyers, personnel directors, safety directors, labor relations directors. Sometimes these are people who are working independently as sort of an in-house expert in a particular area that's important to different parts of the company, or sometimes they're working, basically in a specific part of the company's business. But again, what trips people up the most is the discretionary, exercising discretion and independent judgment requirement for administrators. Another category of exempt employee is computer software employees. These are highly paid employees. Currently, they need to earn about $41 an hour or more, or about $86,000 a year in order to be considered exempt. They're highly skilled. Basically, these are systems analysts, people who are designing software programs or programs for hardware, those kinds of folks. It doesn't include trainees or people who simply operate, maintain, or repair computers. But those types of computer software employees are considered exempt. Next on the slide here, we have outside salespersons. These are people who spend more than 50% of their time outside the office selling tangibles or intangibles, or obtaining orders or contracts. If you've got outside salespersons, it's important to maintain some sort of record to document the time they spend outside of the office, so that if you're ever questioned, you're able to produce records that show that somebody was out of the office more than 50% of the time. Let's see here. There are more questions coming up. I'm going to try to look at some of these. Some of them I may answer at the end when we're done here, or offline if I don't answer them while we're on the fly. We have a question. I guess this says, does this pertain to hourly employees as well as salaried or salaried only? And if that's with respect to overtime, it pertains to salaried employees who fit those. Well, it could be hourly or salaried, but if they fit the requirements of the particular category, then they would be treated as exempt. There are minimum salary requirements for white-collar workers, but as we just saw with, say, with a computer software employees, they could be paid hourly. If they're paid a high enough hourly wage, they would be exempt from the overtime requirements. So let's move on now. And the concept, other exempt workers. Yeah, I just added these here to just give you a flavor of the types of specific employees who are exempt from the overtime requirements. And the important one here is sheep herders. Sheep herders do not get overtime. So again, the consequences of getting it wrong: you have to pay back wages and penalties. The penalties, by the way, are $50 per employee pay period the first time you get it wrong, and if second violation, it's $100 per employee per pay period. Now, if you combine that with what we looked at previously in terms of independent contractors, and you've misclassified an independent contractor for years, the statute of limitations under the Labor Code is 3 years. Under the Business and Professions Code, it's 4 years. $50 per pay period per employee can really add up quickly. So it's important to get it right at the outset. Okay, meal breaks. I'm running a little long here, so I might go through this a little bit quickly. But meal breaks and rest breaks, as we'll see later on, apply to non-exempt employees. So we're not talking about all the people that we just went through, the professionals, the administrators, the executives. These apply to non-exempt employees. And that's because people who are exempt are generally considered to be able to schedule their own meal breaks and rest periods. They don't need to have the employer telling them when to take their meal breaks and rest breaks. So employees get a 30-minute unpaid meal break. This has got to be an opportunity for them to leave the premises, to have a completely unrestricted 30-minute period where they can go and eat a meal. They're supposed to get a 30-minute meal break. If they work 5 hours or more in a day, they're supposed to get a 30-minute meal break before they work the 6th hour. So in other words, if you're going to work an 8-hour day, you're supposed to get a 30-minute meal break before you hit hour number 6. Now, and then there are additional meal break requirements if you work more than 10 hours a day that kick in as well. From an employer's perspective, it's important to do a couple of things. One, establish very clearly in your company employee manual that meal periods will be provided and required. And make that message clear through your managers and supervisors. And then do not, if somebody's taking a meal break at work, go to that person while they're working and ask them to do something. It would be, in fact, it's better if employees can take their meal breaks off-site. Then you don't run into these kinds of. So employers run into the problem of having an employee who likes to take their meal break at their desk, and then boss comes in and says, "Hey, could you handle this for me?" in the middle of the meal break. Boss might not know that, but as the Department of Labor has pointed out, if the employer should know that the person is taking a meal break, then the employer should know not to bother the employee. Now, can an employee waive his or her meal break? No. Employee cannot waive a meal break. However, there are situations where employees have to take an on-duty meal break. In other words, they have to be on duty while they're taking their meal break. That only applies in rare situations where somebody really can't be relieved or can't leave their job site or position or office or whatever it is to go take their meal break. Like, think of an overnight security officer can't leave his workstation. So you don't have to provide an off-duty meal break for those folks, but you do have to enter into an agreement with them so that they understand, they agree that they're getting an on-duty meal break. So that's one type of exemption, pretty much the only one, having to do with meal breaks. Rest breaks, again, non-exempt employees get them. You're supposed to receive a 10-minute meal rest period for every 4 hours that you work, ideally during the period of time that somewhere in the middle of that 4-hour period. This is a paid break. It is not if somebody needs a cigarette break, it's not necessarily that. This is a 10-minute rest break that an employer has to make available to the employee. And I'm going to skip to the last slide here. Well, let's see here. Rest breaks, just looked at that. And again, the consequences of getting it wrong. If an employee, well, first of all, if you have an employee at work and tells you, I had to work through lunch today, you have to pay them an extra hour for having missed their lunch period. That's the meal break premium pay. Same with a missed rest break. For each missed rest break, you have to pay the employee an hour. And then, of course, there are, again, penalties under the Labor Code and interest that can be applied to these. So when an employee comes to you and says, I missed my meal break today, you should pay that person an extra hour of time for the missed meal break. Same with rest breaks. If you don't, employees can then go to the Department of Labor and file a claim against you. This is quite common, that terminated employees will make a claim with the DLSC for years and years of missed meal breaks and rest breaks. And at 3 hours per day per employee, that can add up very quickly. And I've gone over my allotted time, so I'm now going to turn the rest of the presentation over to Wendy.
Thanks, David. There are a number of questions in the chat room, so if while I'm talking you're able to review, and I'll stop early so we can have time for these, at least 10 or 15 questions from people in the chat. So thank you for participating. All right, here we are talking about what happens if the law is not followed. The government has an initiative to get companies to accurately classify its workers. This is called the Misclassification Initiative. The federal government has allocated almost $14 million to help reclassify workers from independent contractors to employees. This is mostly because of unpaid taxes, And also, as David mentioned, people are not getting paid their overtime and meal and rest breaks. There's $10 million in grants to states to help identify misclassification, recover unpaid taxes, and hire additional personnel to investigate. One of these beneficiaries, of course, is the state of California. There's the DLSE, which is the Department of Labor Standards Enforcement. Their mission is to vigorously enforce the labor rules to protect employers who comply with the law from those that attempt to gain a competitive advantage at the expense of their workers. What this means is the government looks at it as leveling the playing field, so people who are paying their workers less by calling them independent contractors, if they're misclassifying it and a competitor treats their company employees as true employees, they want a level playing field. This is highlighted by the Uber versus Lyft example that David gave earlier. All employers in all industries are susceptible to wage and hour claims. There are some questions in the chat room about teachers and such, and hopefully we can answer those questions at the end. A number of wage and hour lawsuits are class action lawsuits. In 2009, a survey was done showing that 75% of all class action lawsuits were wage and hour related. It's more important than ever to comply with the rules. Wage and hour compliance landmines did not just materialize over the last few decades. These have been on the books since about the 1930s. Employers need to awaken to this crisis and attack it from every direction. We are not able to talk about in this webinar the things needed like legislative reform, revised regulations, new case law, and advanced litigation and settlement strategies. What I am here able to talk to you for about 5 minutes more is how to hopefully avoid government penalties and lawsuits. We recommend conducting a wage and hour assessment of your existing policy, procedures, and practices. This self-audit may afford you legal shelter, as it can be done under the mantle of the attorney-client privilege. This means simply that it's not discoverable by a government entity or in litigation. It is far safer to invoke the attorney-client privilege, as if you do it without attorneys involved, even though it's common sense, there's no privilege from discovery for a self-critical analysis. If this audit should indicate that there are gray areas in classification or exemption or non-exempt or timekeeping and wage and hour breaks, then the company can, before the government or a lawsuit is generated, get involved and take corrective action. Wage and hour issues that are commonly being litigated right now is unpaid overtime. This unpaid overtime is the single largest component. And as David mentioned, there are significant penalties in addition to the unpaid overtime, actual payments to the employees. Also, meal and rest breaks, those issues are proliferating. And there's other smaller issues such as unpaid travel time, expense reimbursement, inaccurate wage statements. These are all fair game for government or a private lawsuit. For this audit process, we want to identify the key decision makers. Here on this slide, we see 4 categories. The manager should be involved from a business perspective, what the job should look like. Then we have the people actually doing the job. These are the incumbents. Assessment of an employee's exempt status must be based on the job duties the employees actually do. Human resources, of course, should be involved to review the actual job descriptions, possibly rewrite those, and of course, review key materials. And legal counsel should be involved. One, given the great complexity of the issues, but also to have attorney-client privilege cover. And equally important is legal counsel should be involved to provide training. Training can help employers establish an affirmative defense that can limit damages in wage and hour litigation. All right. If you should unfortunately get indications that a lawsuit or a government claim is pending, we want the company to get ready and get out in front of things. We want to gather all the pertinent documents, identify insurance, and seek out an attorney. Indications of a lawsuit or other issue can come in many forms. First would be, of course, a letter from the government. A little bit less straightforward is when a former employee has requested their personnel file, or if you get a demand letter, that's clear indications that a lawsuit may be pending. All right, that's the end of this presentation. We do want to take questions. So David, I haven't been able to track the questions and answers. Do you want to run some by? Hello, David?
Oh, yeah, I've been trying to answer the questions while you've been doing your presentation. There are an awful lot of them. Some of them are very specific to people's particular circumstances. I've tried to answer those, but I would caution everybody that I can't give a complete answer because many of these things require knowing more specifics about the job or what it is somebody's doing. But by way of example, so we had a question about do the overtime rules apply to seasonal employees? And the example that was given was people who work 40 hours a week, but sometimes will work 8.5 hours in a day. Do you have to pay them overtime? And the answer under California law is yes, you do. If you have an employee who's not exempt who works longer than an 8-hour day, they're entitled to overtime for that extra half hour. Let's see here, and let me try and answer some of these other ones here. Oh, we had a question about whether it's possible to change an employee's status without paying back wages. You can certainly change somebody from non-exempt to exempt. And in fact, if your counselor, your lawyer recommends that, you should do so because it will terminate your liability for back wages. But I think simply changing the status is not going to shield you paying back wages, and changing somebody's status might be a signal that to the person whose status you're changing that you've made a mistake. Might be better to approach that employee and try and resolve that issue rather than just change the status and hope for the best. Let me keep going up the screen here.
There's been a request that we push questions to the screen, so I'll take care of that.
Okay. Well, if you take care of that, then as the questions come up, I'll answer them. Can you do that?
All right.
That'll make it easier.
And again, if we're not able to get to all of these, I just put up our contact information, and it's in the slides that you'll be receiving by email after our presentation. And we'd be happy to follow up and try to hit some questions. We can't get them all here. So here's another one, David, up on the screen.
Okay, yeah. So if you have an on-duty meal break agreement, are you still required to pay the employee the extra hour if they work during their meal break? No, you are not. but you do have to pay for their meal break, the time that they're working, being on duty during the meal break. That 30 minutes you have to pay for. When paying the employee the extra hours set at regular rate or overtime rate, well, you're not paying the extra hour, you're just paying for the meal break. If the employee works an 8-hour day and there's a 30-minute on-duty meal break during that period of time, then you're paying everything at the regular rate. But if they work, as in the last example, 8.5 hours and 30 minutes of that is an on-duty meal break, then you do have to pay them a half an hour of overtime. Can you push another one, Wendy?
Just did, yes.
When do scheduling problems? When due to scheduling problems, staffing is low due to illness, can a campus principal enter into an agreement with a teacher's aide to be paid while she eats her lunch? I'm assuming this is a private school. Boy, I think that's a tough one. It would have to be done on a case-by-case basis. And again, you'd have to be able to demonstrate that there really is no other way that this person can take an off-duty meal break. So you'd have to take a very careful look at your staffing levels, whether you've got other managers, principals, assistant principals, whatever available to relieve an employee. That one sounds a little dicey, but again, they're all very fact-specific, and you'd have to take a careful look at that. Next.
All right, I'll take this one since it was in my area. Do you have an example of a self-audit? I think this is a great question because it highlights the complex nature of what we're involved in. The simple answer is no. A broader answer is we'd want to pull all of the documents, get all of the decision makers involved, and do a thorough analysis based upon a number of checklists and other information. And it's really probably impossible to talk about it here in this webinar, but there are some good practice tips, and we can help with that. You'd contact us after this webinar. So thank you for the question.
I'm reading through some of these questions to see what we can answer here. Let me push this one to the slide area. Here we go. Right. If a non-exempt employee takes a meal break prior to 4 hours and 59 minutes of working, i.e. employee works 8 to 12, lunch from 12 to 12:30, works from 12:30 to 5:30, do we still have to pay the meal penalty of 1 hour straight time? No. No. If that employee takes a 30-minute meal break during that period of time that you've described there, you've complied with the law. Although the way you've written it here, you've got an employee working a 9-hour day. Yeah, so there's an hour of overtime built into that. So you would owe the employee an hour of overtime.
Another question.
There we go. You pushing one up, Wendy?
Yes, there's a new one up.
If the employee doesn't take a break and he wasn't asked to skip his break, are we still required to pay the premium rate? I guess I'm assuming this is a rest break. You shouldn't have to pay the premium rate, but I think with rest breaks, those aren't usually documented. People don't punch in and out for their rest breaks because they're getting paid for them. And so the employers, and when an employee goes to the department and claims that they didn't get their rest breaks, the employer is going to have a difficult time establishing that they did, except by presenting policies that show that rest breaks are required, and what the company's policy is about, and presenting testimony from a manager or other witnesses that in fact everybody took rest breaks, and if an employee didn't take a rest break, the employer was not aware of it and didn't have the means to be aware of it. So I'm sort of expanding on this example because it's quite common. Just from an employer's perspective, you want to constantly be reinforcing to your managers and your employees that they absolutely should take their rest breaks. And once you've done that, if somebody skips a rest break and then later on claims they didn't get a break, I don't think that's a situation where you'd have to pay the premium rate. See another good one there, Wendy?
Yeah. There's a follow-up to one of your questions about waiving lunch.
Oh, okay. Well, yes. By waiver, I mean simply that, you can't have a blanket waiver of your meal period. You can have an on-duty meal period, which is, I think, what's being described here. But like I said earlier, these on-duty meal periods that you do end up paying for, I mean, we're talking about situations where there's where it's really very, very, very difficult, maybe impossible, to provide the person with a 30-minute off-duty meal period. And the typical example would be a single person operating, say, a coffee kiosk, or a security officer who's a sole security officer at an overnight security desk. These are situations where it's really impractical, impossible to provide the person with an off-duty meal break. In those situations, you can have a signed waiver. And that's a waiver in writing between the employer and the employee that says you're waiving your off-duty meal break and working through it, and you're getting paid for it. So what's described here, I don't know. Without knowing more about the nature of the job, it's hard to say whether this is okay or not. I'd be doubtful that this person is in the category of people who really can't get relief from duty. Overtime law is still over 8 hours a day worked or over 40 hours a week. Yes, that's true in California. Not true under the federal law, but it is true in California.
One more?
Another one? Sure. Do these rules apply to salaries?
There's so many keep coming in, so if you want me to stop, let me know.
Yeah, I'm not sure what rules we're talking about here, but the question of whether you're paid a salary or not does not necessarily determine whether you are exempt or not, as we saw from some of the earlier slides. So outside salespeople usually are paid on a commission basis, mostly on a commission basis. They don't receive a salary, considered exempt. But you can pay somebody an hourly wage. If that hourly wage, like in the case of computer software workers, is high enough, then they're considered exempt. So that's the best I can do on that one. Got another one, Wendy?
Well, I think we are on one more, and then push this one.
I have maintenance staff that work after hours doing emergency maintenance. I pay them travel time. Oh. Wow. Well, this one is more complicated. The answer is probably yes. There are situations, well, if you're paying them travel time, you may end up having to pay them overtime, but I think this raises some more complicated analysis. And I'd suggest you review that with your in-house lawyer or somebody who can answer it more specifically. Wendy, I think maybe we're at our 1 hour here, and we have to stop. We will, to the best that we can, try to answer your questions via email later. I would invite people who didn't get their questions answered today to send Wendy or me an email, and we'll see if we can help you out. And let's see, I think our contact information was somewhere in one of these slides, which you'll also be receiving after the program is over. Okay, and I think with that, we're going to go offline.
Thank you, everyone.
Thanks, everybody.